So thank you so much for joining us today for our very first Chimney Corner of Securadin. We are joined today with William Orlewicz, Principal Attorney at Relic Law. He's been so generous to join Will, our CEO, today, and we're going to talk about privacy. Go ahead, fellas.
Hey, Will, thanks for having me.
Anytime, Will. It's always a pleasure to talk with you and learn more about what's going on with privacy.
Yeah, absolutely. So, our firm represents clients who usually have to comply with various global privacy laws and regulations. Those include the General Data Protection Regulation in Europe, but also a lot of the laws here in the United States and in North America. So in the past couple of years, there's been a lot of legislative activity around privacy, with lawmakers wanting to strengthen the privacy protections of mainly consumers in individual states. And California sort of was the tip of the spear in passing sort of sweeping privacy law that will protect consumers, or at least offer them some additional rights around their personal information. And since that time, a number of other states have brought privacy laws online. Those include Colorado, Virginia, Utah, Connecticut, and then with a number of other state houses also having bills pending in their legislature. And then interestingly enough, this sort of patchwork quilt of privacy laws across the country has prompted members of Congress to start to contemplate whether or not there should be a federal privacy law that would apply to all 50 states. And the bill that's currently pending in the House subcommittee is the American Data Privacy and Protection Act, which is a very robust and complex data privacy piece of legislation.
When we look at that legislation and we compare it to things like, that are a little bit more mainstream right now, like CCPA or GDPR, how would that robustness compared to the two? Would you say it's more or less? What are your thoughts?
What you find in the federal law is that there are different sort of tiers of responsibilities for organizations based on their size and the amount of data that they process and sort of what they're doing with personal information. And so you have these various layers that you have to navigate based on what your organization is doing in particular with personal data. And so, unlike CCPA or CPRA, which is the forthcoming California law that supplants the original California privacy law, there are more complexities to determining the thresholds that might apply to your business or your organization. And then there are also additional obligations in there around different types of privacy assessments, risk assessments, and the like. And so it's quite a challenging law for organizations here in the States that have not confronted privacy and data protection sort of on its face before. Our European counterparts, given the legacy of GDPR and its predecessor sort of directives in the EU, are more familiar with these concepts. And so American businesses that have been sort of working at a domestic level have not had so much experience in dealing with how to put into place the types of controls and measures that are needed to meet these new obligations.
That makes sense. When we're looking at controls, I mean, what would be a great place to start? As a normal business owner, a small to medium-sized business.
Yeah. So if you determine that your company, either based on the amount of information that it collects, the types of information it collects, or just simply the size of your company in terms of your revenue, that you're subject to one of these laws, you really need to start to look at these privacy laws and break them down into components. So you have what most people think of are basically consumer rights or data subject rights, which include, the right to access your information, the right to correct inaccuracies, the right to delete or erase information, the right to port your data, the right of data portability, the right to opt out of the sale of your information, and the right to limit the use and disclosure of sensitive data. So those are like sort of right on the surface things that your company will have to be able to do in terms of its consumer audience. But then separately, there are additional requirements around assessing privacy risks and security risks. It can also include data retention and a number of other things, the limitations on the use of personal data, sort of minimizing that, limiting the processing of data to the specific purposes for which that information was collected, and of course, providing notice at the times that information is collected to the relevant audiences. So there's a lot of different components to it, and you really need to break it down into pieces and then start to analyze what, both from a governance and policy perspective, your company or organization needs to do. And then from an operational perspective, how do you adopt those policies, implement them, and put those controls into place so that you can actually demonstrate compliance?
So I do have a quick question regarding employee data. When we're talking about knowing where your data is located as far as targeting like a data subject in the EU, that would absolutely be a part of GDPR, especially if you're marketing to that data subject. Is that a correct statement?
Yeah, so it's really interesting in terms of the application of these laws. So, the GDPR, which is sort of the global benchmark for privacy and data protection, applies how they say extraterritorially. So if you're an organization that collects data from EU data subjects, meaning individuals at the time in the EU, right? So you can be a US company based here, but if they are then in the EU at the time that you collect and process their data, you're likely subject to the GDPR. And that includes marketing products and services to companies or to individuals and consumers in the EU. And so that brings you into the GDPR scope of compliance. Similarly, here in the US, if you are collecting data on, for example, California residents or Virginia residents, Utah, Connecticut, or other residents that have the benefits of these state privacy laws, then you are likely subject to them, even if your business is not physically located in those states. So, these laws have a broader reach than most companies tend to realize at first blush.
Thank you for that, Will. And going just a little bit further, I mean, obviously, let's say that there's a hamburger chain out there that's, looking to make sure that they're privacy compliant. That's not their first job. Their first job is to make hamburgers. But when they're onboarding people, they're creating electronically protected health information through insurance. They're creating PII specifically, social security number, home address, name. Heck, I think an email address is even considered PII sometimes. But would that data for each organization, for just their employee data, fall under the purview of these new privacy laws?
So it depends. Right now, starting in January, there was an employee data exception from the CPRA, or I should say from the CCPA, which is CPRA's predecessor. However, that exemption sunsets on January 1st. So for the state of California, almost all of the privacy obligations that apply to California consumers will extend to employees as well. I cannot say that that's true at this time for the other state privacy laws, but we can probably expect that these laws will broaden over time and that those obligations will also apply to your own employees as well as to your customers. So yeah, and then certainly at an international level, these laws, including the laws in Canada, Quebec just recently passed a very robust modernization act to its Private Sector Privacy Act, and that would certainly capture employees as well.
Thank you for that. One of the biggest issues I have when I'm building information security management systems or a cybersecurity program is we want to look at assets all the time. And I think it's been way past due that we look at PII. I mean, even if we look at HIPAA, EPHI, as an organizational asset, that can not be your focus, but you still have to know what you need to protect. And in my opinion, when we're looking at what the FTC regulations have been handing out recently, and with their addition to GLBA for the financial sector, I really think the FTC is aiming to make the security practices over all of your information assets really applicable to the new privacy laws. Would you, I know I'm asking for an opinion here. I'm not, holding you down to anything. But would you think that's kind of where the FTC is going?
Yeah, so the FTC has really been at the federal level the sort of regulator of record in terms of privacy and security. And if you think about what the FTC's mandate is, it's basically to regulate unfair and deceptive trade practices. Well, going back several years now, the FTC determined that deceptive privacy practices and unscrupulous security practices were within the scope of their authority, and since then have brought numerous enforcement actions against U.S. and multinational companies for things that they thought were unfair or deceptive with respect to U.S. consumers. And it's very likely that they will continue to be the chief authority and regulator if there is a federal bill passed. The FTC also has powers, under Gramm-Leach-Bliley Act, which is a sectoral law, generally, regulating financial institutions, but with privacy and security regulations attached to that law. So, there's a lot of obligations for companies already on the books based on the sector or the industry they're in. Will, you mentioned HIPAA. So obviously HIPAA is going to apply to covered entities and business associates, right, that process PHI, right, health information. And then GLBA, right, Gramm-Leach-Bliley Act, is applying to financial institutions that process what they call non-public personal information of basically customers or consumers of financial institutions. And I think one important thing that companies should remember, we represent a lot of companies that are in the financials. They're not necessarily in the financial space, but do qualify as financial institutions because of various financial transactions that they offer to customers or consumers. So that, a classic example is a car dealership that offers, loans or leasing options to customers. The information that's collected in the dealership's capacity as a financial institution is subject to GLBA and the full brunt of the privacy requirements, as well as the security obligations, which are new and take effect in December of this year. So there's a whole lot going on that companies sort of really need to step back and do a scoping assessment just to determine, hey, what privacy and security laws and regs touch my business, and which ones do we need to be addressing, and then build your governance program around that.
I couldn't agree more. And the more that I look at privacy, I really see, not necessarily running in parallel, but very close at this point. Privacy has a different goal than security does, but security absolutely affects privacy in many, many different ways. When I'm advising about a security program, you were talking about governance earlier. The first thing is you want like an executive sponsorship. Then I would suggest, looking at your regulatory landscape, where are you located geographically? What is your target market? Because your target market, you're going to be collecting data from them because you have to measure as an organization. That's how you're going to make money, or that's how you're going to perform whatever activity it is that you're trying to do, even if you're a nonprofit organization. But if I could say 4 things that would really impact security program, it's executive sponsorship or governance, like you were just talking about, to start identifying state and regulatory controls, self-adhered regulatory controls like ISO 27701, 27001, or business continuity. I mean, whatever standard you are self-adhering to. Perform an audit against those controls and have a risk methodology and risk assessment and treatment plan throughout the organization. And I think if you do those 4 things, you're really going to reduce not only security risk, but I feel that kind of aligns with where we're going with privacy right now. Would you agree, disagree, or would you have anything to add for that, Will?
Yeah, no, I definitely agree. And I think that addressing privacy and security sort of in tandem makes a lot of sense. There's certainly many opportunities to collaborate. For example, you mentioned an inventory a little bit ago, Will. And what we find is when we do a personal data inventory to determine what information the organization processes, sort of on a category by category basis of data subject, usually that leads to developing a list of third parties, often vendors, right, in the form of applications and other systems that the organization shares information with. And that asset inventory is just as usable by your security team and in developing your security plan as it is for privacy and building the privacy related compliance artifacts. So a lot of these efforts are interrelated. You could say the same thing for incident response and data breach and many other aspects of these 2 sort of parallel systems.
I agree. That also kind of gives me another random thought. When we're looking at the privacy implications of incident response, quite a few things going through my head. First of all, if there is an incident that you need to involve regulatory bodies from a state or federal level, what would the first action that you would have be? And the reason I'm asking that, let me posit it a little bit further, is yesterday the FTC came out with a ruling where they were actually going to go after an executive of an organization because of poor security practices under the label of privacy. That's kind of where I'm headed. What would you have to add in with that?
Yeah, obviously, one of the biggest areas that businesses of all sizes are really worried about is what their exposure is in the aftermath of a data breach, right? That is an event in which some form of personal information or personal data is compromised, either through a ransomware attack or through unauthorized access that leads to the exfiltration of the data, or even an insider threat actor who steals information, right, for a nefarious purpose. And those types of events are security events, right? By their nature, are violations of a security policy. But where privacy comes in is what happens and what are your obligations with respect to those affected individuals after this occurs. And so the various regulators that you contend with are going to depend on the individuals whose information was impacted and perhaps what industry you're in, right? So for example, if you're in the healthcare space, right, and you're a covered entity, right, then HHS is going to regulate you, and OCR, the Office of Civil Rights, is going to enforce your obligations to report that breach not only to them but also to the affected patients, right? So that's one example. At a state level, aside from California, which has now stood up a separate agency to enforce privacy, within the state, almost all states delegate this power to their state AGs, their attorney generals. And so when you have a data breach, many states are going to require you, depending on the number of impacted individuals, to notify the state AG. And I can tell you from firsthand experience, representing clients in these matters, that they will contact you and they will ask questions, right? In the financial services space, again, it could be the FTC as your regulator, but it could also be a state level regulator that regulates financial institutions within the state. So for example, here in Michigan, there is a new Data Security Act on the books specific to insurers, right? Insurers and insurance producers. So, your insurance agency down the street that sells, life insurance, auto insurance, or what have you, title insurance even, those companies are regulated not only at a federal level, but also at a state level and have security and reporting obligations for breaches that occur, within their business. So there's many different regulators that could come into play. And that we haven't even talked about international regulators where you have data from outside the US, which is very common in many businesses these days that collect information online and the like. So it's an enormous task to try to figure out which regulators are in play. And then you have to be able to navigate both, your response obligations in terms of timing, content, and manner, but then also responding to those regulatory requests to try to avoid liability. And then obviously beyond that, like for example, under the CCPA and CPRA, if the reason that the data breach occurred was due to, for example, unreasonable or lax security practices, those plaintiffs have a private right of action to sue you directly. So those affected parties, can form a class action and bring a lawsuit directly against you and seek statutory damages. That's under the state law. And then at the federal level, right, they can bring any type of case so long as they can establish standing, meaning they've experienced some sort of cognizable harm. So there's a lot of different exposures, including contractual liability to your business partners and the like, and on top of the regulatory risk that these companies face when something like that occurs.
Now you offer some services in case of an incident, correct? What type of service would you offer to help the organization that doesn't know what their regulatory landscape is, but they got hit by ransomware? They obviously know there's an issue. What advice would you give for that organization? Should they run across ransomware and then need help, but they really don't even know where to go?
Yeah, I mean, that's a big deal. And so, we've represented a lot of clients who've had ransomware incidents and other major data security incidents. And usually it's an emergency, right? So, our firm has a 24-hour breach hotline you can call, and you can usually reach an attorney to start to unravel what's happened. But normally we respond with an incident response team. And so that's an outside team that we bring in to basically triage your situation, start to collect digital forensics, and start to examine what's happening with your environment that needs to be immediately addressed, right? And so we're going to follow a phased protocol for that. And depending on the nature of the situation, in this hypothetical ransomware, right, the question will immediately become, can we restore our systems without negotiating and paying this attacker? And if we can't, because we don't have sufficient data backup or recovery capabilities, then we have to start to look at, can we legally pay this attacker, right? So there's been a lot of movement in the past 12 to 18 months by the U.S. Department of Treasury, basically saying that they're going to enforce OFAC violations for companies that pay, right, bad actors ransoms. So obviously, the U.S. has a lot of, especially designated nationals and sanctioned, groups and individuals who, if you pay them, right, you put yourself in legal jeopardy. So there's an entire legal analysis that centers around that in the ransomware space. Obviously, from there, it's determining whether or not you have a notifiable event, right? So under most state laws or other laws, it'll be, has there been an unlawful access or acquisition of personal information? And if there has, right, if that determination is made based on the findings of the incident response team and the attorney, you'll have those notification obligations. And that's where sort of the legal, sort of crises start to begin, really. But these are ugly situations. And therefore, the best advice is to avoid getting in them if possible, right? And usually that starts with implementing good security, good data management practices, right? Shrinking your data footprint so you're not holding on to data longer than you need to, and doing everything you can to sort of minimize your risk of exposure to these types of things.
Thank you, Will. That hotline will be in the link below the video. So if you do want to call and chat with Will or a team, if you are unsure of what's happening in the organization and you think you might be affected by ransomware or a data breach, Will's team will be able to help you out. Now you were talking about scoping a little bit earlier, and obviously we have regulations, state and federal, that are coming at us. But before we had this, mainstream privacy, I have always, been under the impression that your outward-facing privacy policy really creates where the FTC can make a judgment. Because if you're making a statement that this is what you're doing in your outward-facing privacy policy, they're going to make you adhere to it. I know the DHS is going to be doing that too, and Health and Human Services has done that as well in the past. So when writing that privacy policy, what would you suggest for organizations to do, especially when it's going to be public facing?
Yeah, so, interestingly enough, when I first got into the sort of privacy legal space, everyone thought of privacy as basically the privacy notices that were on people's websites that nobody ever read, right? And frankly, that for a long time, that largely was the case. It was basically, an organization's representations about what it does with your data, right? What data does it collect? What does it use it for? Perhaps who it shares it with, how long it may retain it, what options do you have? Can you exercise choice with respect to various uses of it, and the like, and perhaps who to call if you have questions about what they do with your data, right? And it was sort of limited to that, and organizations had a ton of flexibility in what they said in those statements. That has all changed with the passage of these new laws, because these laws mandate that those disclosures contain very specific pieces of information, right? So you need to disclose specifically what information you collect, right? Who are you sharing it with? How long you're planning to retain it? What their rights are? How they can exercise those rights? Sometimes who they can complain to, right? The regulator themselves, and that type of information, and a whole host of other things. So those have obviously now sort of been made more inflexible in terms of there being a specific recipe that has to go into each one. Now, to your point about the FTC, what the FTC does in, again, enforcing unfair and deceptive practices, will look at organizations who, for example, say one thing in their privacy policy but do another. But perhaps the biggest area that they've enforced privacy has been when an organization states in a privacy policy that it does one thing with data, right? Then changes that policy to say that it does another thing without notifying those individuals, right? So for example, you log on to a website, you share a bunch of information for a very specific purpose. Let's say you're buying a product or signing up for a service, and they say, hey, we only use your information to process your order and to, put you on our mailing list. Okay, great. And then, 2 weeks later, after you've already engaged with them, they publish a new privacy policy, and they take the data that they received from you under the auspices of your original privacy policy, and they start selling it all over the place to third parties who are now brokering your data and pushing different products and services on you. And you're wondering, hey, how did you even get my information? How come I'm being spammed? How come you have my phone number and you're sending me these texts at all hours of the night, right? That's how that happens. And the FTC will look into instances of that conduct, and they will investigate that. And sometimes the organizations have created the evidence against them by having these two policies side by side. And the FTC, the only question that's relevant is, hey, did you apply these changes to only the new users, or did you apply to all the legacy users upon which you collected their data under different, pretenses? So that's a huge area of enforcement for them, and it's very easy for them to demonstrate.
And that's a great point. When you're looking at legacy data versus new data, when you change a document, or in this case, a privacy policy, not only can you really grab attention from the FTC for not adhering to the rules that the original legacy data was, but you can actually talk yourself into adhering to regulations that you don't need to. And the example I use is, you don't want to have a policy that is aspirational in nature. You want to make sure that it is completely accurate for your organization. And that goes for all of the security documentation I've ever worked with too. But especially when you're looking at the FTC, if I was in Ohio and I wasn't doing business with California, and I state on my privacy policy that I'm CCRA compliant, that will actually walk me into regulatory issues when I don't even have to be. Is that a correct statement, or what do you have there?
Yeah, no, I think that's right. I think, in some cases, companies make misassumptions about which laws they're actually subject to. So there's a legal analysis that needs to go into that determination. For example, if you don't meet the thresholds of the law, then unless you have some sort of contractual obligation, for example, you're doing business with a large business partner, and they've said, hey, despite the fact that you're not subject to the law, we are, and therefore we're going to flow down these obligations to you via contract because we have that obligation under the law, or something to that effect, right? I would not represent that you do things that you don't actually do. And some companies get pinned between a rock and a hard place. So they actually are subject to one of these privacy laws. Therefore, they put that recipe into their privacy policy stating, hey, this is all the information we're expected to disclose to you, and here's all the things that we do in compliance with our obligations under this law or this regulation, but then they don't actually have the engine under the hood to demonstrate that they do it. And that happens very frequently. And therefore, those companies have risk, because not only are they not complying with the actual law that they may be subject to, but they're also misstating what it is that they actually do. And so, that's a really tough position. And, we try to work with clients to move as quickly as possible to put in place the pillars of compliance that they need in order to meet both requirements.
Thank you, Will. We are at time. So is there anything you'd like to add to our audience? I mean, this is going to be the first one in a series of privacy conversations for us. I believe the next one we're going to dive into GLBA a little bit further, and the changes for vendor management and privacy and security related there. But is there anything that you'd like to tell our audience today in closing from what we've talked about?
In closing, I would just say, stay aware of what's happening legislatively. Stay aware of movement within your own industry in terms of privacy and security laws. There's a lot happening. It's a fast-changing landscape, and the regulatory interest in enforcing these requirements is surging. So it's really not a time to kind of bury your head in the sand. It's pretty much time to start to wake up to these requirements if you haven't already, and start to look at how you're going to build out the governance to manage these compliance programs.
And if you are already in a security program like SOC 2 or ISO 27001, you're already adhering to about half of what the privacy requirements are from an organizational level. I would like to add that Will is telling you that you also need legal representation when you're looking through those policies. A privacy policy in particular that's public facing absolutely has to have a legal review, and not by rocket lawyer, by an attorney that understands your organization, your business. That's how you're going to reduce reputational risk and privacy risk when you're going through that process. Thank you, Kara. Thank you, Will, for coming today. And as always, thank you for watching us and helping us learn a little bit more about privacy. And we'll see you on the next time.
Thank you.